Good morning. The Court of Appeals is now in session.
Good morning and welcome to the Court of Appeals today. We have one matter on our calendar in the matter of KT. Counsel, if you would please enter your appearances for the record, that would be helpful.
Good morning. This is Greg Stevens. I'm here on behalf of the appellant.
John Peterson, Assistant Attorney General for the state of Utah.
Thank you. I know, Mr. Peterson, that you have come before us before in this online setting. I don't know if we've had the pleasure yet of having you appear virtually, Mr. Stevens. So I'll just briefly explain the proceedings, how we will proceed today. Both sides have 15 minutes in which to make their oral argument. The only different thing about there's other things about not being in person, but really the main thing to remember is that while you are not arguing, if you would please turn off your camera and mute your microphone, that helps us with the bandwidth and helps us be able to concentrate on the attorney that is making the arguments at the moment. It appears that, Mr. Stevens, you have reserved 3 minutes for rebuttal. Does that comport with your wishes?
It comports with my hope. We'll see.
Better way to put it. Thank you. And I think, do either of you have any questions before we begin?
No, Your Honor.
I do not.
Perfect. Then, Mr. Stevens, the floor is yours. Thank you.
Thank you. May it please the court, the counsel. I think there's essentially two main arguments here, and the first, I think, is probably the most important. I think the juvenile court exceeded its statutory authority when, in its final order substantiating allegation of abuse, that the court went beyond its statutory authority by substantiating based on facts contained in an amended petition to which the parties agreed, not on supported findings contained in that amended petition, but based on facts stated in the amended petition that the court had accepted in its adjudication order of April 13th, 2021. Adjudication order is a final appealable order, and the only thing that's supposed to happen after the adjudication is disposition or other proceedings, not substantiation. And under the statute, under the provision that the court relied on, 78A-6-323.
Does the statute preclude the court from doing so? I mean, the facts of this case suggest that that issue was reserved both by the court and by, well, at least by the state for sure, and maybe even by mom's attorney. So are you saying that the statute precludes such an event or a decision later past the adjudication hearing?
It should, but I think in this case, I think the state has a fair point on that. And I think you have a fair point on that, is that it was reserved at the adjudication hearing. So at least arguably, the adjudication hearing was really continued. Arguably, anyway. It would have been better if the judge had said that, because they called the next hearing a disposition hearing. And when the adjudication hearing was over and when the adjudication order was entered, that should have ended the issue. But unfortunately, we do have that wrinkle there, is that they did continue it to, or they reserved the substantiation issue for another hearing. But I think even if we accept that the adjudication hearing was actually continued rather than ended, the statute doesn't permit, the 78A-6-323 doesn't permit the court to do what it did. Under that statute, it allows the court, would have allowed the juvenile court to substantiate a supported finding. And in that amended petition, the facts on which the juvenile court relied were not the prior historical supported findings. Rather, the court went off and used the same facts that it had adjudicated as finding of neglect as the basis for its conclusion, substantiating for abuse. And I think those three prior instances had ended, and they had ended by way of a adjudication in those cases where there were supported findings. But those weren't the supported findings that the juvenile court relied on here. And I don't think it could, because that statute, section 323, begins by saying it's upon the filing of the court with the petition under section 304. So it clearly contemplates that you're looking at the facts that comprise the petition that was filed in this case, not in prior cases. So the state was arguing that these prior supported findings are sufficient, but that is, first, it's not what the court did, and it's not what the statute allows.
So explain that to me a little bit further, in the sense that my understanding is that the court didn't use those. In the amended petition, there's at least three. DCFS has the following history with the family, and so then lists three supported findings of emotional abuse, chronic emotional abuse, and domestic violence related to a child. Those are in the past. That happened in the past. And then in paragraph 6 of the amended petition, the state lists facts that it believes supports that the child is neglected or dependent. But didn't the court adjudicate those, take admissions, or at least 34E admissions, to the facts in that paragraph? And the fact that the court adjudicated based on the party's stipulation that adjudicated the child as neglected, why is the court precluded from finding those same facts, using those same facts to substantiate abuse?
Because the statute that allows the court to substantiate for abuse, the former section 323, talks about supported findings by the division, by DCFS. Those facts in the amended petition were not supported findings of abuse by DCFS. They were facts which the mother admitted, or to which the mother admitted, but they weren't facts that were decided by the division to be supported findings of abuse.
So what needed to be, what's missing then from this amended petition? Like, what would make something a supported fact versus a non-supported fact?
Well, they say so. For example, in those prior historical ones, they say the court supported findings for abuse or in these prior cases. And when they did the amended petition, so that the mother was willing to agree to it, it starts off and changed in each one of those cases where in the facts that were actually used by the juvenile court in this case, and says DCFS believes that, and changed all of the language where it said DCFS supported findings for in every instance in which there was an allegation of abuse.
So there's a difference between, what is the difference then? I'm sorry, this may seem like a really stupid question, but what is the difference then between DCFS supports these facts and DCFS believes these facts?
I think it's the legal significance under the statute is when the DCFS saying they believe something is simply alleging that it happened. And I think when DCFS say they've supported a finding, that's more definitive, at least as far as the court's concerned, as far as the statute is concerned, where it actually uses a language where it talks about the division making supported findings. So I think it has a statutory significance and therefore a legal significance to the court.
And the functional distinction, as I understand it, Mr. Stevens, is the difference between an allegation and a determination.
Yes. Although it's not really, I mean, it's a determination by DCFS. And so, you know, it's not a court order, it's not a court conclusion, but that is correct, I think. And so the other, besides the statutory, exceeding in statutory authority, I think the court, when it accepted a stipulation and also the legal significance of the stipulation, the court was also bound by the legal conclusions stated in the stipulation of the parties reflected in the amended petition, because both parties did agree to that, and the court adopted it and accepted it as a stipulation of the parties, and then also for its finding and conclusions in the adjudication order. Does the court have any more questions? Okay, I'll reserve the rest of my time. Thank you.
Oh, Mr. Stevens, I thought you meant on that point. I did have a
No,
question.
on any point at all.
Okay. You have your third argument clearly brought in the alternative, suggesting insofar as the state has this right, then prior counsel was ineffective in not acquainting your client with the details of that different protocol than what she had in mind. Counsel should have advised that this reassessment could happen. I think logically that's a fair inference, but I'm not sure that we have anything in our record that would confirm that counsel in fact failed to make the disclosure that you think counsel should have made. Am I wrong about that? Is it more a matter of inference and fair deduction as opposed to something you can point to that would make clear that counsel never walked her through that alternative analysis that you think counsel should have?
I did want to make sure I understand. So your question is whether there's anything in the record that says or that shows that counsel told the mother that the findings in the petition were definitive for purposes of substantiating for abuse down the road.
Well, I guess that's the flip side of it. I was wondering if we had anything in our record to support your contention made on appeal that counsel did not let her know that despite the stipulation as she understood it, the state could ask the court to substantiate the more severe grounds, and if the court so chose, it could do exactly that. How do we know that counsel didn't give her that advice?
And that's fair, Your Honor. There is nothing in the record that would say would support that. It's simply, as you said, a logical inference that, especially given counsel's rather adamant opposition to substantiating for abuse at the final hearing or what they call the disposition hearing.
Thank you.
And are you in any way asking for a remand to the juvenile court for factual findings on that issue?
I think if the court were to decide that we're wrong on the first 2 points, that is what we'd request. If the court were to decide that she should have advised the mother that the findings could be used later in a substantiation proceeding.
Thank you. Perfect. Any other questions from the panel? Looks like you will have your full time on rebuttal, Mr. Stevens and Mr. Peterson. Thank you.
Thank you.
May it please the court, John Peterson on behalf of the state of Utah. I guess I was just going to start maybe with kind of an overview, basically. I mean, when DCFS goes out and conducts investigations, they will at close either enter supported, unsupported, no merit findings. And in some of those cases, we'll also go to the juvenile court where the facts of the investigation lead them to believe the juvenile court jurisdiction is necessary. Yeah, But so basically you have two worlds out there. You've got the world of like the database and the investigation, and you have perhaps the juvenile court in some case, and in some cases those will overlap. And I mean, but even if there were not a juvenile court case, if there was investigation and supported findings were entered, then the parent is given a notice of agency action that they've been placed on the state database based upon this finding. And basically section 323, that was the old numbering, so I can tell you the new number if you need it, but section 323 is basically a matter of judicial efficiency, because if a findings on database, and especially there's two databases, there's the basic database and there's the licensing database, and severe types of abuse and neglect will go on the licensing database. And a person who wants to challenge their inclusion on the licensing database wouldn't necessarily need to go to juvenile court rather than an administrative tribunal to hear it. So section 323 essentially says, why should we have two trials in juvenile court on the very same issues? It allows them basically to be merged together, but still there are differences obviously between them. A finding of abuse, neglect, or dependency as a basis for jurisdiction in the juvenile court must be entered by clear and convincing evidence, whereas upholding or substantiating the supported findings by DCFS is by a mere preponderance. And so, do you have a question?
I do. Mr. Peterson, explain to me where then in this petition, the amended petition, or is it in the court's adjudication order, where DCFS supported the findings, where DCFS supported its findings of abuse?
And I guess there's some confusion, because paragraph 5 does list some historical findings, and as counsel, if you look at the transcript from the hearing of June 25th, I believe. Anyway, the hearing where they talked about this, they discussed that there's 3 in them, and some of them are past. And as Ms. Wood, who was a trial attorney, suggested, their 2019 and 2010 ones were older, kind of water under the bridge. Whereas the March 2020 is actually one. There's their prior investigations. One thing started in the fall, and then continue. But I mean, so essentially, those are prior past facts, and then as you noted, Judge, paragraph 6 is the operative facts that they're adjudicating, and then there's a general prayer that they substantiate the DCF has supported findings, and everybody's sort of pretending there's some kind of great mystery about what these findings were. But as I noted, once DCFS enters these supported findings, and that Ms. Kumansky was sent a notice of agency action. So everybody is very much aware that there were parallel findings. Judge Kenny.
But is that really true, though? The thing that I find curious about all of this is I understand your point about the structure, that there's these sort of 2 parallel tracks going on, and that there's different consequences associated with each of the tracks. But if I'm the mother and I get this amended petition, and I read the amended petition, I looked at paragraph 6, and paragraph 6 says that the state is alleging that, quote, the following incidents or facts support the conclusion that the child is neglected and or dependent. And there's nothing in paragraph 6 in which the state alleges that it's also asking for a determination that the child is abused. I go to the end of this, there's nothing there. You get to the conclusion on page 5, the capital letter section, which says, wherefore DCFS prays for an entry of an order, and then paragraph 3, quote, determining that the child is neglected within the meaning. And so everything in this amended petition screams, we're asking for a determination that the child is neglected. And I just don't see anything here that says that we're also asking for a determination the child is abused. And so then when the court comes in a couple months later and says, well, I'm going to springboard off of this and now find abuse, I'm just not sure what to do with that, if I'm the mother or if I'm somebody else who's not familiar with the intricacies of the 2-track system that you're laying out. That's what I'm stuck on here.
And I would note that it's not just mother, and her attorney, and there's been speculation that this wasn't explained to her, but as Judge Orem also noted, there's nothing in the record suggesting that she did not actually receive proper professional assistance in interpretation of this and her resolution of the matter. And I guess my answer to you, Judge Tenney, would be that the petition alleges neglect because this is a petition seeking jurisdiction of the juvenile court. initially it was a petition for protective supervision, which actually changed to a custody matter later on. But I mean, but the allegations in this petition are that for purposes of juvenile court jurisdiction, the child is neglected, and that was, the party's stipulation. The original petition had sought findings of abuse, neglect, dependency, and the modified amended petition changed it. But the petition still requested that the underlying supported findings be substantiated. And so there's basically two prayers for relief. One,
And where is that? I may have missed that. Where is that language in the amended petition that we're going to do a separate substantiation on abuse that's separate from the neglect determination that the state's explicitly asking for? Where's that first part?
Oh, I'm saying that the prayer for relief in paragraph
7 at the end, right?
Substantiating the DCF supported findings. And I mean, and I guess the argument that Mr. Stevens makes is it's somewhere in the petition before paragraph 7 on the prayer for relief. There should have been, DCFS supported these findings that they're requesting substantiation of. And what I'm saying is, and I guess my argument would be is that there wasn't any kind of mystery. Ms. Kuzmansky was, given a notice of agency action that these were pending, and the state requested that they be substantiated as part of the court's resolution based upon, essentially I guess it would be collateral estoppel, the kind of argument that these facts have been admitted. These facts are sufficient to uphold, the supported findings and make, as they say, substantiate them, which is what happens in the juvenile court, affirms the prior supported findings. Is that responsive, Judge Tenney?
Yeah, it is. Thank you.
Thank you. Sorry, I got off track. A couple of things. I guess we haven't discussed greatly the question of ineffective assistance of counsel. I do agree with Judge Orem that the record doesn't really support the arguments made. And as I noted in my brief, it's somewhat of an open question to what extent she was even entitled to effective assistance of counsel in this case, at least in this portion, given, again, there's two things going on here. Clearly, with regards to the adjudication of neglect and juvenile court's jurisdiction over her and the family, she was entitled to effective assistance of counsel. But, had she gone just to an administrative panel body, she would not have been entitled to appointed counsel. And to my mind, there's two facets of it. It may be that this court finds that right to effective assistance is a right to effective across the board. And we're not going to parse it out in half of a hearing, but to the extent that in court finds she was entitled to effective assistance, there's nothing in the record to suggest she didn't get that. They made a deal, and the deal was, and she got something realistic. There was not an adjudication of abuse, there was an adjudication of neglect instead. And then part of that resolution, the state clearly from throughout the course of these proceedings continue to ask it, and we're going to have the court uphold the supported findings. And that was exactly what happened. That issue was reserved, but it was merely continued to another hearing to allow all the parties to argue. And again, they argued it, and mother's arguments didn't prevail at that time.
Can I ask you what might be a silly question, Mr. Peterson? But what is the substantive difference for a finding of a supported finding of neglect in the DCFS database and a supported finding of abuse? Is there any substantive difference for a parent or a caretaker or somebody? Is one worse than the other?
I don't know that they're necessarily different. There is a difference between a severe finding of abuse neglect and a regular finding of abuse neglect, because severe findings and other things like sexual abuse, like I said, go on the licensing database, which does preclude employment in certain areas, whereas being on the DCFS database, the main MIS database, is really a matter largely of historical record. It may impact you if you wanted to, do kinship care or foster care or something like that, but by and large, it's not going to impact your life dramatically. People may feel there's a different in degree between, you know, hurting your child as opposed to just not taking very good care of them. I mean, I think we'd all probably suggest that, but I mean, they're not that different. I mean, they're both fault-based, unlike dependency, which would be the no fault-based finding. The only thing I would just note is that to a large extent, the arguments made now about lack of jurisdiction and lack of authority, to my mind, were not well preserved. If you look at the transcript at, I think it was page 4, I mean, the mother does say, I mean, she says, counsel says the statute doesn't allow it, but to my mind, the statute doesn't allow it is not really preservation. There's no explanation of how the statute doesn't allow it or why. There's no discussion of jurisdiction or that the fact that the court no longer has jurisdiction now that we had the adjudication hearing were done. So I don't believe those arguments were preserved at all below. So I mean, and so they're not properly before this court either right now. If the court doesn't have more questions, I think I've set forth what I wanted to.
Looks
Thank you
like,
very much.
thank you, Mr. Peterson. Mr. Stevens?
Can I start you off with a question?
Sure.
Can I respond to what Mr. Peterson said in response to my question? So if we go to paragraph 7 at the very tail end of the amended petition, there is this line where in the prayer for relief, DCFS is asking the court to, quote, substantiate the DCFS supported findings. Why doesn't that get them there?
Because it, as the court was claiming that it did, and also in the amended petition, it asks, it says the DCFS is going to ask to substantiate, but it's asking to substantiate for supported findings. And in that amended petition, there are no supported findings for abuse. And so the court, the parties, including the state in the amended petition, asked the court to substantiate for supported findings. And that's a key term defined by the statute.
Let me just push back on that. I mean, if I go to 6A, which is a couple pages earlier, one of the assertions is that, quote, DCFS believes that the mother is emotionally abusive to Kent. 6C, which is on the next page, says DCFS believes that the mother is physically abusive to Kent. So it does use abuse as a verb or as a term throughout. So why can't they then piggyback off of that and jump into that?
And I think this is similar to Judge Christiansen's question, is that it is different because saying you believe something is an allegation, but saying something is supported has significance in the statute. And that particular sentence that you had read at the conclusion talks about substantiating for supported findings. And so by the terms of the amended petition, those aren't supported findings. They're just, they are, the DCFS believes that. And it's essentially, as you know, in a criminal case or an SEC case where somebody's either admitting or denying the allegations, they are the allegations, but it doesn't mean they're supported findings. And as far as prior question by Judge Christiansen was the significance of abuse versus neglect in a database. I think, and this is, I can't really argue, not part of the record, but people lose their jobs when there's a database that says they abused their child. That it has more significance, it carries more weight than if somebody is in a database as having neglected their child. So it does have significance. It does have meaning, and it does have meaning to people who access a database. And I have nothing further unless anyone on the panel has any further questions.
It does not appear so. Thank you, counsel, for your arguments today. We will take this matter under advisement and render a written decision as soon as we can. And it was nice to see both of you, and we will be in recess. Thank you.
Thank
Thank
you.
you, Anna.